No drop frames? Oh, you know what? Crap. I don't, We're connected to your Wi-Fi. Can you, you know what? I don't have it. I don't have it, Kaley. I don't have another USB port open. I don't know that I can. We just might have to suffer whatever we suffer from dropping a frame. Yeah, we've already dropped 2% frames. Hang on, guys. I'm going to come right back up with the thing. Yes, let me see if now this works. All right, I don't see any dropped frames. I am wet. Sorry, everyone. And trying to find some Christmas music for you. Let's see here.
What about the special occasions?
Special occasions. Yes, it's under special occasions. Christmas! Is there a Boxing Day one? I don't know.
Probably not.
I don't see anything.
I don't think we get special songs for Boxing Day.
Here's a instrumental version for you. Hello, everyone. Let's see. Are we actually running now? We are. I have to turn that off. There we go. Stream is good. Excellent. I can turn off closed captions. Why those are on, I don't know. They're on for you, not for me. Hello, everyone. I'm Leonard French, your favorite copyright attorney. And, of course, I'm here with Kaley, my lovely friend and staff member and girlfriend. And we have a Duke of Wellington cone for you tonight, except that I'm kind of roasting at the moment, so I will put that back on once I dry off. I thought we would do a live Q&A for you here. I've lost OBS again. There we go. 0 dropped frames. Zero dropped frames. We were at 2% dropped frames before, and then I got myself all flustered. There we go. You can't notice the wet if I put my hair up. How is everybody? Happy Boxing Day. Merry Christmas. We are great. Oh, I'm not getting none of this desktop audio is coming through. Hang on.
Oh, that's not.
That's a problem. Let's say headphones, F-Series. There you go. Now you have the music, and you probably have Brandon as well. Let's try Brandon again.
Can you hear me? Hello?
Yeah, chat, confirm if you can hear Brandon now, because they were off before apparently. Getting all of our technical glitches.
Are the frame issues on my end or on your end?
I don't know. Are there frame issues? I can't really tell because I really actually, shouldn't be downloading our stream as I'm uploading. Yeah, here we go. You need to change the video resolution. The expected video resolution is 1080. What?
You weren't first the other day to do that.
Okay.
Well,
yeah, what's going on?
Can we do a mic check for me? I want to hear from chat if I'm super quiet. Like I
You are quiet.
Yes.
Darn it.
You are super quiet. Let me turn you up. I'm going to turn you up to 200%.
Typical tactical.
I know, it's like a Canadian thing. Like, I'm not used to shouting unless there's hockey.
You must project.
All right, I'm going to take the stream down again, and we'll bring it back up in 1080, because that's what YouTube wants, I guess. Sorry. All right, I'm just done with that music. That was terrible. All right, how are we now?
Christmas music.
How are we now? Let's see. Now it says we are not receiving data at a fast enough rate. Oh, but it says good, so that's not that message anymore. Weird. Hello, everyone. Thank you. Welcome back.
Try number 3.
Attempt number 3. Yes. I'm going to have to trim the front of this video when it goes live afterwards. Anyway, welcome back. Merry Christmas and Happy Boxing Day. This is a viewer special just for you. And, well, actually, it's kind of for me, too. I missed you guys, and I thought we could answer some of your questions. I didn't really feel like or have time to prepare a whole video for you today, and I had a couple edits for videos that we went over on Sunday, and none of them just really felt appropriate for a holiday, so why not just go live and talk to you? Because that seems more appropriate for a holiday than anything else. So, Merry Christmas to all of you. I see a bunch of you in chat. Hello and welcome. Wanted to answer basically any of your questions that you had for copyright attorney Leonard French, but I do have one question that keeps coming up, and I thought I would get to what you should do about false DMCA claims right here at the beginning. But give me just a moment to get everybody in here, make sure you're all here. Oh, we missed you too, mate, says Six String Ed Thing. Hey! Or Six Stringed Thing. Could be either. Could be either. That would be either six. I'm going to guess it's Six Stringed Thing, but Six String Ed Thing is also kind of a fun way of thinking about that. Is it sad that I'm not sure if I'm joking or not about YouTube's takedown practice? At least they didn't decide that the stop motion effect was too much like Gumby. Yeah, so that's the problem with YouTube's takedown system. Actually, I guess that's one of several problems with YouTube's takedown system these days. Not only is it automated, but because of the way the law is written, and I know this is kind of an unpopular, not opinion, I mean, it is my legal opinion, but it's more like this is the law. If YouTube receives a DMCA takedown notice, they must follow it. It is the way the law is written. It is not really YouTube's fault when a third party sends a takedown notice and then YouTube takes something legitimate down. It's the claimant's fault. And the trouble is that YouTube obeys these DMCA requests basically from anybody without vetting them. But they're supposed to. YouTube is not bound by any law, and in fact the opposite is bound by the law they're trying to follow to obey the takedowns. And you have to sue in a court of law in order to vindicate your rights. And that's a difficult thing in concept, I understand, but it's also not the hardest of lawsuits. It's basically a small claims court lawsuit, but it's in federal district court. And while that sounds really tough and sounds really complicated, it's kind of one of the simpler lawsuits you could have in federal court. Federal court system is actually really nice. Many things are allowed to be filed electronically. Even pro se litigants in some court systems can petition the court or ask the IT staff of the court for a login for the filing system. Many attorneys can file things like me from around the world. As long as I have an internet connection and I can get access to the court system, I can file things for your case or whatever. So there are only so many barriers to this, and I hear a lot of energy being put into, well, why can't we sue YouTube, or why can't we just prevent false claims, or why can't we this or that, when the real answer is we should be putting that energy into suing those people. I have prosecuted and defended these kinds of claims before, and again, it wasn't a very hard lawsuit. I think the lawsuit cost about $6,000 of attorney's time and investigation time total. That sounds like an awful lot of money, but it's also nothing for a court case, and it doesn't necessarily have to come to that. That was only because an attorney was representing. It's also possible to file one of these things on your own, or file one of these things in forma pauperis, and no, you don't get a free attorney, but it's not that hard to write out a legal claim for this kind of false copyright infringement. And courts often take, and have to take, pro se litigants more seriously than they would take a lawyer litigant. And that, I don't mean that in a bad way. Lawyer litigants are supposed to know what they're doing, and if a court sees a mistake or a problem, the court will just tell that lawyer, go figure it out and come back. Whereas a pro se litigant is given more leeway. And so it's sometimes a good thing to have no attorney and represent yourself. Is this legal advice? Am I telling people who have false claims, go and do this and surely you'll win? And no. You need to look things up. You need to know a little bit about what you're doing. And we're trying to figure out how to bridge this gap, how to help people bridge this gap. If you've received a false claim and you want to go to the court, well, what court do you go to, and how do you get service on the defendant? And well, you're not going to know all of that. You're going to have to look all of that up or have help with some of that. and an attorney is going to want basically maximum dollar to help you with that. And that's a problem. That's the problem from my perspective, is not that you can't sue, it's that it costs money. So we're trying to figure out, what could we do from our perspective? How could we help you, or how could somebody help you in prosecuting these false claims so that they stop happening? And the trouble with that is that some lawyer needs to get paid. I have student loans, or another lawyer will have student loans, or I have bills and such, and we lawyers didn't go to school for 12 years to live in poverty. I don't want to live in poverty for the rest of my life, or owe student loans when I die or something, so, I'd like to make a dollar too. We have to all support each other. We have to figure out how a law firm could be giving a public service, like providing low-cost or no-cost DMCA false claim prosecution and legitimate claim prosecution and defense, and how that could be funded. Normally, you would write some grant applications and ask for some money from a state. Well, copyright's a federal law, so no one state is going to want to help you defend and prosecute DMCA claims. So then you have to petition the federal government for that money, and all this becomes much more complicated than anyone would like to deal with. So what I'm trying to say is that you're not wrong for being frustrated. However, the problem's not going to go away unless we all figure out a way through this. And if we don't figure out a way through this, I don't expect anything to change. That's just more or less a status update on the DMCA false claim process. I don't know that I have anything more to say about it right now, but I just had to get that off my chest, because for the past week or 10 days or so, I've been answering questions about false claims, and pretty much every answer comes down to, if there's been a false claim, you have to sue. Feedback on that? Does anyone have any thoughts?
It's kind of a catch-22, because in order to them, you first have to show the system that there's a problem, and most of these issues get settled. So, there's a lot of times where rulings don't happen.
Whoa, hang on. What do you mean settled? Settled means both of the parties have settled. And no one's talking about, a settlement of something paid or not paid, or walk away or not walk away, or whatever. I'm saying that someone... So what do they do now? Let's back up a second. What do you do now? Most people file either nothing at all, or take the video down, or file a counterclaim, and the counterclaim process means that YouTube will back off after a few weeks, 14 or 30 days or something like that, if the opposing side, if they file a counterclaim, or even if they say that yes, it's a thing, as long as you file a proper counterclaim, they have to more or less back off and let the court system decide and that's only if the plaintiff files something. But many people either don't want to deal with it and delete the video, or allow the claim, or don't file a counterclaim for some reason. Can a collective of content creators make a class action lawsuit? In theory, yes, but the standards or the rules for class action lawsuits are that you all have to have a common instance of law and fact. In other words, you all have to have a common claim stemming from a similar or same incident. So if the false claimer made mass false claims all at the same time as part of the same transaction and occurrence, maybe, yes, you could get class action status there against the claimant, not against YouTube or anything like that. But if they are different transactions and different videos and different times, you're getting farther and farther away from a situation where you could do a class action. And while a class action sounds easy, that's also not easy. The law firm that's filing the class action is expected to fund the class action. So no, yours truly especially would not be able to fund a class action. The law firm is also supposed to be experienced and competent with class actions, and yours truly is not experienced or competent with class actions. So we would have to overcome all of those hurdles and either find a law firm that is willing, or we would have to raise money and be competent, and you're getting farther and farther away from reality here with this.
I'm sorry if I misunderstood what we were talking about.
Oh, you haven't misunderstood. You're okay.
It's just a lot of people are saying that the system is flawed, and
the law is flawed.
Yeah, that's what I mean by that.
The law is flawed, and YouTube's automatic identification systems are flawed. They aren't the same thing, and they don't necessarily result in the same false claims. If you've received a false claim because YouTube's Content ID system accidentally or automatically flagged you incorrectly, that's not necessarily the same as a lawsuit against the claimant situation. You could still pursue some kind of lawsuit or arbitration against YouTube, but you're going to be arguing basically actual damages because of their automated thing. And really, who knows what's going to happen to you since you've now sued YouTube? Who knows if they're allowed to retaliate against you by removing your channel or something? I don't know. So I get, as the further I explain, the more and more complicated it sounds. But I've actually been a lawyer representing in these kinds of lawsuits, and at least from my perspective, they aren't complicated lawsuits. They're easy lawsuits. You literally have one claim, and it's a few pages long, and somebody has to prosecute it. It can be done. You can raise money for this, and really, how many of these things do you think we're going to have to do before the situation finally gets changed? Okay, but enough about that. We've been here to talk about 20 hours, or 20 minutes on that.
20 hours.
20 hours.
Oh, God.
Here somebody sent me a link to the Fat Rat. Christian Friedrich Johannes Butner. Successful YouTube channel, recorded and posted an original music video, 47 million views, helped him place among the higher echelons of YouTube's hit makers. A scammer claimed ownership of it through YouTube's Content ID system. He appealed and was denied. It appears that YouTube simply allowed the scam itself to wait until the last possible moment to respond, then to decide for itself whether it was a legitimate appeal. Well, yeah, this is where you would need to go to court. It only got sorted out when he got lawyers involved. Now, this is what I don't understand. The scammer probably didn't issue a fraudulent DMCA takedown. Well, yes, Content ID isn't copyright DMCA takedown, but Content ID still involves claiming ownership of a video, and there's laws against that, and there's defamation of title or slander of title when you claim ownership to something that's not yours. So if maybe his lawyers didn't argue those things or didn't have to, but exactly what I've said here, you have to get lawyers involved in order to get something moving along here. And if it's a false claim, those lawyers have the right to get paid by the false claimant once you vindicate your rights. Unfortunately, none of that happens unless a lawyer actually takes it on and does it. So we're exploring step 2, which is whether I would be willing, and anyone who works for me would be willing to help vindicate these rights in a broader sense. But let's move on to your other questions.
I believe there's a question that was a super chat.
Okay.
From Joshua Walker, and so he was asking about. I'm assuming that I'm just supposed to pronounce the initials, and it's not a word, but TOEI.
TOEI. Can you ban a game from being played in tournaments? That's a good question. Well, so first I'm going to analyze it under copyright law. Under Section 106, 17 U.S.C. 106 of the copyright law, you have certain rights. These are called the copyrights. You have the right to prevent copying. So the question is, in a tournament situation, would Dragon Ball Fighter Z be copied illegally? No. You'd have to make sure everybody has a copy of the game. You have the right to control public performances of the work. Maybe they have the right to control some public performances of their work, but arguably, you are still committing some kind of fair use because your use is transformative. You are making creative inputs, and the creative inputs are what causes the game to play. And that's kind of a iffy argument, one way or the other. You could have a court battle there, or an uphill battle, or a disagreement with TOEI over whether having a tournament is publicly performing their game, but maybe you could overcome that by hosting a private tournament where you are not casting or streaming the tournament to people publicly, and instead are only hosting it for a private tournament. It's still a public performance in a certain way, so you still have to overcome that. But okay, you have the right to prevent distribution of the game or your copyrighted material. You can control who sells it, basically. The first sale, you can control who you sell it to, not who sells it from there. So no, that's not being implicated by a tournament. So I'm thinking, yes, you could find a way to hold a tournament using someone's game. And I bet you there's case law on this, because I bet you board game makers have tried this before. And I'm not saying Scrabble or anybody has done it, but you would think that maybe somebody hosting a Scrabble tournament might have to pay a license fee to Scrabble if they're publicly performing the copyrighted work. And there's probably case law as to whether or not a Scrabble tournament publicly performs the work. But think about this, though. There's different kinds or different levels of copyright that you would get involved with here. Just a tournament doesn't tell me if it's publicized, if it's broadcast on national TV or worldwide TV or YouTube or Twitch or something. That changes it. If it is not being broadcast anywhere, that's one copyright question. If it is being broadcast, that's a second plus, possibly more copyright questions. So your answer is unclear because, of those things. But those are the things you would need to overcome. You would need to overcome basically the right of TOEI to control the public performance of their copyrighted work. And so you would be arguing that it is not a public performance, that it's a fair use in a private tournament or something. And if someone is going to host tournaments for Dragon Ball Fighter Z against TOEI's wishes, I would recommend they have an attorney and be ready for whatever fallout is about to happen. Good question.
Well,
hey, go ahead.
I was just going to say that Toei is one of those Japanese companies that isn't entirely respectful of American copyright law. So you have to be careful around. It's like Nintendo was or is. I don't know if they still are, but they obviously.
Nintendo did back off of their creators program, and remember, the creators program was the code word for a restrictive program. It was not a program encouraging creators to make things. It was a program discouraging creators to make things, because you had to turn over rights to your channel or videos and take a cut give Nintendo a cut of your pay, basically. You're already meager pay from YouTube. Nintendo needed that, right? Huge corporation Nintendo wanted your few cents from your videos instead of those few cents going to you. So no, it's not necessarily a great situation. I'm fully aware of that. We got to keep pressure on, keep fighting the good fight.
Yeah.
Overlapping Magisteria asks, thank you for your donation, by the way. Hey, Leonard, if a corporation is a U.S. citizen, what are your thoughts on the same rights going to AIs and chimps? Well, I have to read over Citizens United again because it's not 100% a U.S. citizen. The court said that a corporation has personhood rights when it comes to donating money to a political candidate. And so that means that a corporation can donate money to a political candidate under certain rules, and I don't remember exactly what all the rules were, but it led the way for super PACs and stuff like that, so that almost nearly unlimited funds could be donated to a candidate as long as that corporation is not acting in collusion or coordination with the candidate. This pisses me off because corporations, if they are to have personhood rights, then they should have all the rights and detriments of personhood, which means that they live and breathe and can die the same way that people can, and they can't do that, so why would they have personhood rights? This is basically like saying we can create extra people by filing paperwork for corporate formation. I don't like this. You could create a virtually unlimited number of corporate persons and use that to create a very confusing system of donations or a system of holding companies, etc. And we see some of that today, but I don't know that it creates a slippery slope for rights going to chimps. Now, my professional opinion aside, I do believe that animal rights should be something where animals are treated as equal beings, not necessarily with the same guarantee of outcome or even equal opportunity or anything as humans. I just mean the equal right to not be subject to pain and suffering and torture. So I don't expect chimps to have personhood rights, but I would like to see them have animal rights. AIs are going to be an interesting question. You see this a lot coming up in books that have been written in the past 50 to 100 years about the possibility of artificial intelligence. The AIs, if they were able to reach a level of sentience, at some point they would deserve some kind of rights, similar to human rights, wouldn't they? Or animal rights at least, depending upon the level of sentience, right? Otherwise, people can go around causing great suffering to this sentient AI, and that could have consequences too. So, you know, you'd really want to think about how people are equal and why. And it's not just because we're made of flesh, or it's not just because we are arguably the most intelligent beings on the planet. I think that you can cause great suffering to things that are other than humans, and that's just as bad as causing great suffering to humans. But this is something we could disagree on. Do I have an opinion on Eric Lundgren versus Microsoft? I don't know anything about that. Or Disney's attempt to copyright Hakuna Matata. You may be missing the word. I think it's trademark, not copyright. Copyright is different than a trademark. A copyright protects creative expression. A trademark protects use in commerce. So I believe it is Disney trying to trademark Hakuna Matata. So I'm getting my wires are all getting wrapped around myself here. I really am. I'm totally messed up here. Give me one sec. So Disney is trying to trademark Hakuna Matata, if I understand it correctly. I don't actually know the details, so I'll just speak generally. The trademark protects the source of goods. So if Disney is trademarking Hakuna Matata, It is going to be in a category of goods, and it is going to be for their use in commerce. Now, does Hakuna Matata deserve trademark protection? I don't know. You'd have to see how they're using it in commerce and whether or not it's overlapping with some other use of a trademark. You'd have to remember that trademarks are by country. So Hakuna Matata trademark would be in the US or wherever Disney has filed for it. And it doesn't mean that people can't use the phrase Hakuna Matata. It means people can't sell things using the phrase Hakuna Matata. So I don't know what the big deal is. Disney wrote The Lion King, and they wrote the song Hakuna Matata. And although Hakuna Matata, I'm sure, are just regular words in somebody's language, that doesn't mean it can't be trademarked. You can trademark regular words in a language if you use them in commerce in the proper way. So as much as I think Disney is sometimes evil, I don't see why they can't get a trademark on Hakuna Matata if they're using it in commerce. No, it's not a VLC hat, believe it or not. I understand everyone that it's a traffic cone and therefore it looks like a VLC hat, but no, this is a Duke of Wellington hat. I have visited the Duke of Wellington in Scotland, in Glasgow here, in Glasgow Central, and this is his hat. I took this right off his head. Don't tell my bar association. I'm not supposed to steal from the Duke of Wellington. They forbid that.
He still has his, what's it called, fairy light coming out of its horse butt.
We found, we went and visited the Duke of Wellington statue in Glasgow Central, and someone had put not only a cone on his head like usual, but also a string of battery-operated lights coming out of the horse's butt. And I have it on video, I just don't have it prepared for you.
It's at the end of one of the videos. Also, killing time, it's not at George Square, it's at Royal Exchange Square. Just saying.
Kevin also wants to know, how do you store all your hats?
Currently, I have a house in the U.S. that's big enough to store all my hats. We are running out of room.
He has real estate for them. He bought a separate house, and he keeps it humidity controlled.
Well, actually, you're not far. You're really not far off. I was literally on the phone with my parents today and a couple days ago, because as I was leaving for Scotland, I connected my thermostat to the internet, and something in doing that reset the way the system interacts with the heating system, and my house went from 55 degrees Fahrenheit to 91 degrees Fahrenheit for 4 whole days before I noticed it. I sent my parents over there. They confirmed that my house was like a sauna and turned off the heat, and we turned on a couple space heaters. And they went back today, a couple days later, to check on it, and it was fine, about 52 degrees inside. And we were concerned about next week is going to be well below freezing in the U.S. where my house is. So the little space heaters I've got going, if they don't keep up, I've got a major problem. So my parents and I were actually able to troubleshoot over the phone and get the heating system operating again, and my house is now hovering at 57 degrees Fahrenheit on its correct heating system, and I'm very much more relieved that that is not going to be a problem. Yes, I will have a nice bill. I will have a nice bill.
I was going to mention the bill, and I was going to mention that if that had stayed at 91 for 3 weeks, there's things there that might have not been good for stuff. I don't know where I was going with that. Sigvard
Johan Lochny Hjalmus asks, why heat it when you are not there? Well, first, you wouldn't want the house to drop below about the dew point. About 55 degrees Fahrenheit is a good safe above the dew point. Yes, Blackleaf, I have a special wireless thermostat, not a Nest, but a Honeywell. And it was not really the thermostat's fault. It was Honeywell's fault because I asked them for the instructions to connect the thermostat to Wi-Fi, but the instructions instead reset the thermostat, and they did not tell me they were resetting the thermostat. I might actually ask them what they're going to do about my bill since I followed their instructions, but yeah, it's not going to come of anything, I'm sure. But why keep the house above, why not empty the pipes and just let the house freeze? I'm only gone for 3 weeks, and it's really not good to let all your stuff in your house freeze. Plus, I have lots of electronics and cameras, and who knows if they're supposed to freeze, and what happens if they freeze with dew on them, and now you've got water frozen on something like a camera sensor or something. So much easier to just pay the bill and keep it at 55 degrees. Oh, and no, I'm not keeping it at 57 with anyone there. That's just cold enough to keep dew from forming and keep pipes from freezing. It'll be going back up to 72 when I get home.
Stand-in Stan actually has a good law-related question.
Yes.
About if you're allowed to practice law in any state, or does your license only cover the state you're in?
So your license covers the state you're in, but there are procedures to practice law in other states or in federal court in other states. So for me, the unique situation is that I have a license in a state, but copyright is a federal law and is a more or less uniform law across the nation. The law is uniform, but the court's interpretation of it could change from circuit to circuit, or from district court to district court, or even from judge to judge in some cases, like the strike three holdings cases that we're seeing in DC and New Jersey now. Courts have said one thing, and strike three has said, whoa, that's not how it works, and we have to get judges to agree individually before it goes up for an appeal. So that's going to be interesting. But if I want to practice law, say, in Colorado, Colorado has the ability where I can take a test or pay a fee or both, I think it's both, and suddenly I'll be a lawyer in Colorado. However, I'm not interested in practicing Colorado state law. So guess what I did instead? I paid a $250 fee to Colorado. Actually, it turned out to be $300 this year. And I am now an attorney, fully licensed to practice in the federal court system in Colorado. I am fully admitted and licensed to practice in federal court in Colorado by paying a fee. It's just the way they do business. Same thing in the Western District of New York. I am fully admitted, which is basically licensed. I'm not licensed by New York, but I'm admitted to their court system based on my Pennsylvania license. I am fully admitted in the Western District of New York Federal District Court. However, what happens if I want to practice in the Northern District of California, or in the District of New Jersey, or in the Southern District of New York, which is Manhattan or New York City? Well, then I need a sponsor, and the sponsor wants to get paid, and the court wants me to abide by certain rules for either insurance or, for New Jersey's case, for example, paying into a state benefit program or something like that. So New Jersey, for example, is approximately a $500 fee if I want to appear in a case in New Jersey. New York City is approximately a $350 fee if I want to appear in New York City. Northern California is another like $400 fee if I want to appear in California. And that's before we get the local council's fee of $1,500 or $2,500 just to start getting their practice geared up for whatever I'm about to do in federal court in those systems. This is a problem because I'm an experienced copyright attorney in a particular kind of case. I should have no trouble going from court to court to court around the country arguing for legitimate, meritorious defendants and plaintiffs. But instead, I have to fight this extra battle of I've got to have enough money, and I've got to get the money from my client, and I've got to get a local counselor who believes in my case, and et cetera, et cetera, et cetera, et cetera. And I actually really do believe this is a terrible problem that prevents access to justice. So I talk about it and I bring it up as much as possible, like right now. Butters! Taking the LSAT on January 26th. Took it before with limited self-study, got a 149. What do I do to study? good luck with the studying and all that. I'm not saying one way or another how you'll do. I'm very curious to see if you'll get a better score, because the LSAT is supposed to be an aptitude test, not a knowledge test. It's not, your ability to study for it should not change your score. Now, I got a 154 on my LSAT, so 149, really not that bad. I was able to get into a law school, no problem. I didn't get into Harvard or anything, but I also didn't apply to Harvard. So I don't know. But look at your various law schools, look at their score ranges, and apply to a school well, apply to a couple schools, but apply to a couple safe schools and apply to your favorite schools. And if you don't have you don't get into one of your favorite schools, then you have some fail-safes to fall back on. At the end, you look exhausted, apparently. At the end of the day, unless you're going to try and be one of the top 10% candidates for big law, it doesn't matter. I have never had anybody, I've never had a client, I've never had a boss, I've never had anybody ask me what my scores were or my GPA was or anything. Yes, some of those things mean things to what they call big law, one word, law firms. And I have some opinions on that. I don't think that's necessarily the right gatekeeping to be doing for working in a large law firm. But they believe in that, and it works for them. And you know what? I can't compete with it. So I can't really knock it too much. I don't believe in it, but then again, I'm not one of them, so could just be personal bias. Maybe I'm jealous. I also don't want to work 2,400 hours a year, so that doesn't work for me either. Darter 9000 says they took the LSATs four times and got the exact same score each time.
Well, at least you know the test works. Jeez.
Blackleaf, why did we time out Darter?
And Satan.
Blackleaf, what's going on?
What the heck?
Blackleaf? Somebody want to tell me what's going on with Blackleaf?
I'll go find out.
He says, oops. Those were legit questions. Those were not things that I would have banned people for. Okay. Anyway, that aside, why do we look tired? Why am I sweating? One, it's because we just got finished with Christmas Dinner 2, called Gourmetin 2, and I took a shower, so I'm hot, and it's also 10:45 at night, 22:45 at night, and I'm no longer jet lagged, so it's very late for us here in Scotland. That's why. Rogue admin.
Actually, it says Rouge admin, which is even
Rouge. Rouge admin. Any more questions? Let's keep going.
I think Tactical said she was keeping a list or something at the beginning of the stream.
Okay.
Yeah, so let me look at some of the questions. There's a bunch of questions about how your time has been in Glasgow, and are you struggling with the strong accents?
Yes, I don't understand anyone with a strong accent, but that's okay. I eventually get it, and then when they realize that I don't understand them, they try to help me understand as well, and it mostly works. People only seemed a little bit annoyed, which is okay. Kaley will probably be laughing at me for the rest of our lives about the things that I don't understand or know. You'll all get a kick out of the fact that I bought 2 one-way train tickets instead of a single round-trip ticket, which, by the way, they're the same price. A single round-trip ticket is actually more, a single one-way ticket is actually more expensive than the whole round-trip ticket. But somehow I still managed to buy 2 one-way tickets instead of a single round-trip ticket.
Oh, Leonard.
Oh, like at his
I mean, we're talking about 270 versus 250, not like hundreds of dollars, but.
So, I mean, your reasoning was like, I thought I would buy the return for once I go home.
I didn't understand what a return ticket was. That's the problem. Have I met Big Clive? Is he in Glasgow?
Who is Big
I would
Clive?
definitely want to meet Big Clive if he's in Glasgow. Holy mackerel, yeah, definitely. We're going to have to try that. We're going to go to Loch Lomond later this week. We're going to do the Clydeside Distillery and the Transport Museum. And apparently I'm going to try and figure out if I can say hi to Big Clive. That would be awesome.
Haddock Man, I did give Leonard fried marshbar, and there's a video on it on his YouTube.
Yes, I have a public, not unlisted video, but it was not posted with notifications to you. I posted it as an unnotified video, so you didn't receive a notice of it, or shouldn't have. And I did try a fried Mars bar, and I did sample some Iron Brew today.
I didn't like it.
Oh.
It will have to grow on me. It also has caffeine, and I don't really drink things with caffeine.
Killing... I can't actually read. Killing Time... I need to get my glasses, maybe.
Soshal Street?
Please say that again.
Soshal?
Shasha?
Sochial?
Socky Hall.
Socky Hall?
Socky Hall.
Sucky Hall?
Socky Hall.
Well, there you go. I just said it wrong.
I thought you had it.
I stop paying attention for like 10 seconds to read something, and then I come back in, and everyone's just like, Sucky Hall? Like, what
Yeah,
did I miss?
Leonard,
What just
Leonard,
happened to the
you said it-
conversation?
You said it like you would say the name of a town in Pennsylvania.
Yeah,
Soshal.
yeah. Well, I'm from
Yeah.
Pennsylvania.
In Pennsylvania, they say things very strangely.
Yes.
That's what I've noticed since
Could
I've
you
been
grab
here.
me something to drink? Whether we've
Catasaqua?
got some of that
Iron Brew?
Coke would be great. The caffeine-free Coke.
Around here, we have Catasaqua and we have Copley. Those are the two that always mess with my brain. But I said them both right, so.
Manitoban, what's the DMCA question?
Oh, that was about the where the burden of proof is when someone issues a DMCA takedown, and shouldn't the burden of proof be on the person making the claim?
Yes, and don't take this the wrong way, but this is a fundamental misunderstanding of the DMCA process. It's a common one. I'm really not trying to make you feel bad about it or anything. I'm saying the DMCA process is not written the way you think. It's instead written from this perspective. So you would normally expect that it would be written from, say, the either claimant's perspective or false claimant's perspective, or the recipient's perspective, or should I say the content owner's perspective. It's not. It's not written from any of those perspectives. It's written from the perspective of the content host. And it says, thank you very much, it says that the content host will be immune from prosecution if they follow the DMCA takedown procedure. The DMCA procedure gives no leeway for YouTube or the content host to account for a false claimant or disobey the DMCA process. Now, those things are practical. If YouTube has identified a false claimant and knows that the false claimant is not going to ever be able to successfully file a lawsuit and maintain a lawsuit, yes, they can successfully ignore that DMCA takedown, but that requires so much of their investigatory efforts. They have to know with a level of practicality, they have to know for sure that the false claimant is a false claimant. So forgetting that for a moment, let's try to put ourselves in YouTube's shoes, or look at this from YouTube's perspective. If YouTube wants to be a video or video content host that makes money, that makes a profit, which so far I don't think they've made a profit in all of their years of operation. If they want to make money, they're going to want to automate as much as possible and deal with as little as possible while maximizing the amount they can deal with and still have a attempt at a profitable website. So YouTube's motivation is to stay in this safe harbor, this immunity from prosecution or copyright infringement claims. And so they're going to implement whatever DMCA claim process needs to be done by law in order to prevent themselves from not being in their safe harbor, in order to stop themselves from being outside the safe harbor. So it's not that YouTube is being terrible in not identifying false claimants. It's that they literally have no legal standing or purpose in doing so. They could stick their neck out. They could go outside of the DMCA process and defend your claim from a false claimant. But they're now outside of the DMCA safe harbor, and if they got it wrong, now they are liable. And it really could be either party that now brings them to task for that liability. So no, if they stay strictly within the DMCA process and obey it to the letter, then nobody can sue them successfully for anything. That's why YouTube does what it does. Questions?
All right, we have one from Ronald Liebrink asking, what laws in other countries do you find better than their U.S. version?
Oh, good question. I am not a terribly good scholar on international law. Let's see what we can think of.
Europe is great.
Kelly says Europe is awesome.
I think they have good laws and bad laws just like we do.
Yeah, but generally speaking, that's not a very interesting answer.
Yeah.
Oh, what about the Polish thing that we were talking about with The Witcher? The ability to overturn copyright ownership no.
Right. Right,
you're right. There was that, and there was also
there was a Polish copyright law. Remember, there was a Polish copyright law that said under certain circumstances, if you license something away to someone, and the new user, the licensee, had a giant windfall from that license, that they owe you some reasonable portion of that above and beyond the original license. But several Polish scholars or citizens or people who were attempting to be scholars contacted me and were explaining that although it does literally read like that, Polish case law says it's not actually enforced like that. It actually means something different. But that was an interesting one. I don't agree with that. I think that's not necessarily a great law. I do agree with the American principle that if you contract away your rights, you've contracted away your rights. Otherwise, contract would not be sound, and I can't think of a world where we would want contracts to be not sound.
Now, what about the situation with the Halloween copyright?
Okay, what was that about?
Do you remember it was the creator of Halloween got his copyright back because it wasn't being used or something like that?
There's a couple ways that can happen. There is such a thing built into an old copyright law about clawing back your license under certain circumstances, and there's also a situation where you could write it into your contract where if the copyright is not being exploited, then it reverts back. And you might remember this is how that terrible Fantastic Four movie got made. They had to make it within a certain period of time, but there was no requirement that it be of a certain quality, so they just made a shitty movie, even though it really wasn't helping anyone. At least they got to keep their copyright, right?
Well, that's also what happened with Spider-Man. That was the whole reason why they made Amazing Spider-Man 2 and then immediately rebooted it again. Or no, they made Spider-Man 3 and then they made Amazing Spider-Man like a year or two later, because it's the same situation. They have the license from Marvel, and it's in perpetuity as long as they continue to make movies.
Litigator asks about my perspective of common law versus civil law. I don't really know that I have a perspective. They're both sources of law, and I have to research both of them when I'm filing something. Common law is more of the law that courts have recognized over time. It's not where any one court just made up a new law, but rather courts had to deal with situations that the law is either ambiguous about, or sometimes the law is literally unwritten, and the court has to decide, okay, well, how would we deal with this? If I, you know, if two parties, you know, let's say two parties have an auto collision and it's difficult to tell who's at fault, how do you go about then determining how much fault to be assigned to the other? Or what if something is just a complete accident and no one is actually totally negligent or willful or intentional or something about it? Well, you still have to have a principle that the party who caused the accident, even if they didn't mean to, that they still have to pay or something. So courts have had to recognize these things over the years. That's common law. Civil law and criminal law are the written law. That's law that's been legislated, passed by a recognized body like the U.S. Congress and the president signing the bill or something. There are two cats, Lucy and Penny. The little one that you just saw with the cow print is Lucy, and the big one
does not like you at all. Let me find Penny.
Yeah, Lucy doesn't like me because I poke her with my fingers when she jumps on me in the middle of the night.
Penny. Hello.
So I'm going to steal Butter's question for a second.
Sure.
Because he was asking about your education, about what did you do before you got into law school and how that might help you. And if you could also expand on that, and exactly how many other like certifications and degrees and side careers and paid hobbies do you actually have?
Well, first, as one of my friends from childhood would say, he'd call me a polymath or a Renaissance man. I'm not living my life trying to be that. I actually was hoping for a much simpler life than I've had, but part of me just has this insatiable need to know everything. So I have definitely dabbled in a lot. This can be a detriment, though. We live in a day and age where being good at one thing can often be way better than being kind of good at many things. So it really, take your chances one way or the other. I think I can give you some better advice, though. If you, or I'll first start with my history. I wanted to be some kind of engineer. I went to school for electrical and computer engineering, and I was looking forward to a career working for a pair of professors who were working on what would become the iPhone touchscreen, or rather the capacitive touch sensors. And the, you know, life is what happens to you while you're busy making other plans. Things happened, and I was unable to finish my engineering degree. It was both, I was too young to be trying to undertake that much responsibility. I was too immature to undertake that responsibility. And then there were also real things that happened in life. My girlfriend cheated on me, my parents lost the family business, and I was one of those, I was raised in a family or in a way where making mistakes was not an option. It was, and I don't recommend this, by the way. You should not raise your kids to be afraid of making mistakes. Everything should be taken in moderation. Certainly you don't want to encourage someone to wantonly make all the mistakes because they're not doing any planning or any attempt to whatsoever to plan or be prepared for things. At the same time, you don't want someone to be so afraid of making mistakes that they won't do anything at all. And Fortunately, I was somewhere in the middle. My environment was very much geared towards you shouldn't make mistakes and you're punished for mistakes, but at the same time I have this insatiable need to know everything. So fortunately that second part won out eventually, and I realized that the fastest way to learning is doing things, and the mistakes you make, you can correct those along the way. So, long story shorter, my mistakes, I was able to finally stop feeling very worthless and very useless, and I decided to go back to school. In the sense of why I went to be a lawyer, that more so had to do with things that happened in between. I was working for an engineering company, and I was doing basically an electrical engineer's job, and I was hoping to work my way into an electrical engineering position, or at least working alongside electrical engineers. And I was already very close to this. I was basically an engineering technician, process improvement engineer, and I was working my way towards being able to design my own products. I do actually have one product with the company where I combined two products that did not work together. I wrote the protocol to make them work together. And I have another product with a company where they used to take about 3 weeks to take initial data from a job site. I have a non-disparagement clause with this company, so I'm trying to be very careful about my words here. It was a company that did electrical work for large buildings and homes and things, and so you would have large amounts of spreadsheet data, every electrical load and every logical lighting zone, and the operation of these things. And another engineer, another software developer, had the idea that, hey, we could take all of this and put this into a spreadsheet, and had done much of the preliminary work to create a spreadsheet or two that could then be imported into a tool that we worked on. I took this tool and took it to the next level, and I had 5 or 6 or 7 different spreadsheets and wrote them all in VBA with tooltips and smart formatting and everything, and then went and wrote all the C# code to import all of this data. And in the end of the thing, what used to take 3 weeks to go from someone writing down everything on a spreadsheet, I told them, no, take your laptop, write it all down into my spreadsheet first, and then you never have to transcribe it again. We literally had 3 full-time data entry people transcribing these things. So we took that from 3 weeks to 3 days, and then by the end of the thing, I was able to do 3 weeks worth of a job in 3 hours. Unfortunately, the company and I still had a falling out after that, and that led me to want to pursue a career in law. I was tired of getting screwed and not understanding why. So now I get screwed, but I understand why. So it's much better now. And I owe $300,000 in student loans. But so long story short, it doesn't necessarily matter your journey. Just have a journey. Take the journey. Make the most of your journey. And try to, have a career. Like, basically, don't just do nothing. Do something. Be passionate about it. Even if it's not your career, even if it's just your day job or whatever, be good at it. Be passionate about it as best you can. Help the customers. Make a difference. Someone will notice, and someone will give you more opportunity, and somehow you'll be able to put these down into words on a law school application or a job application. Basically, what I'm trying to tell you is the world is run by those who show up, and you should show up with a good attitude, and you'll be fine. You won't necessarily make $1 million automatically, but you're not going to be nobody. You're going to be somewhere already ahead of the curve because you showed up with a good attitude. Oh, Blackleaf, thank you for your contrition donation of $10. Paul Delaney also gives $10 and says, the Fun Pimps makes a 7 Days to Die licensed Telltale Games. Whoa, what?
He's
what
saying
he's trying to say. There's a game called 7 Days to Die.
Got it?
And they licensed Telltale Games to basically port it to consoles, but obviously Telltale Games kind of went bankrupt and closed down. So
Yeah.
are they able to get back their license so they can find a new publisher for consoles?
Good question. We need to know the status of that bankruptcy because a license to Telltale Games would have some value. That value would need to be accounted for with that bankruptcy court, and the bankruptcy court and Telltale Games will basically determine whether they're pursuing that license or not. There should be a way to get back that license, and if someone's going to want to review that from a legal perspective before anybody makes any decisions there, that you definitely want a bankruptcy attorney to review that along with your copyright attorney if they're not the same person. That's a tough one. Ultimately, you need to make sure that that license is either dead or can be clawed back or is voided or voidable, and that Telltale has no further expectation legally in that license. It would have value. It would have to, if it has value, it would have to be declared on their bankruptcy filing. So I would expect a bankruptcy court to be dealing with that if they are truly in bankruptcy. If they've just shut down and they're not in bankruptcy, license is probably void. Can't think of any way that any argument that a shut down company could make that they still own something. I don't know. Good question.
I don't exist, but I still own it.
Yeah.
We have
UK without your guns.
That's a good question. How is the UK without my guns? I'm fine. I'm a little bit pissed off at the huntress who took a goat off of Islay or whatever. Islay? How do you pronounce it? Islay. Off of Islay without permission. She had a gun. Why is she allowed to have a gun? She didn't pay for that gun. Somebody else paid for that gun. Pisses me off. If I'm not allowed to have a gun, you're not allowed to have a gun.
My best friend since childhood, Officer Mike, has surprisingly stepped in and asked, do you think that student loans are a burden on a student, and would you recommend getting one?
I'd recommend avoiding them at all costs.
Depends the country you're in.
Yeah, know what you're getting into. If you are going to go to school under student loans, do everything you can to minimize the amount you need to take out. Live in absolute poverty if you have to. I'm really not kidding, because you'll be paying them back forever. And I have no idea how we're going to deal with these student loans in the future. Like I said, see, here's the problem. Remember when I said as the moment ago that I went to school under all these circumstances? I was pretty messed up. I don't mean like I was seriously mentally ill or anything. But I was definitely suffering from anxiety, depression, sort of a hopelessness about life, and sort of an overly hopefulness that anything at all might be a way to make life better. And so I definitely jumped into the student loans, get a law degree in any way possible and figure it out later. Yeah, I'm figuring it out later now. So that part of me is suffering, and I'm going to have to deal with that. And so that's why I'm doing the whole nonprofit. I'm trying to be going to do the nonprofit thing, figuring this out at some point here shortly, and hopefully getting my student loans paid off. I actually would recommend that you don't take student loans if you can avoid it. If you have to take student loans, make sure you're only taking government loans, because the private loans will get you too. They're a little bit worse than the government loans, because they have more restrictions and things, and there's less things the government can do to you than private institutions.
But that's depending, that's America. In Scotland, for example, my tuition fees are all free and paid for, and I only pay for maintenance loan, and even then, on a yearly basis. Monthly basis, I only pay a small percentage, and after a while will get written off. Apparently 66% get their student loans written off because we never pay back within the time, so...
Yeah, Butters, I'm not big law. To go to big law, You not only have to be a top 10%er, top 5%er in your class, you have to go to the right school, you have to have done the right extracurricular activities like moot court and law review and all that. And you have to basically throw yourself at the mercy of the big law system. You're trying to impress these big law lawyers, and it's a club. To an extent, it is or was a boys' club. I read regularly about the sexism problems in big law, and I'm not saying that every law firm is sexist, but you have to deal with all of those kinds of problems. You're dealing with working for another attorney, and in big law, you're dealing with working for many other attorneys, so the problem is compounded. Again, you could have a great experience, but you could also have a really, really terrible experience if you don't know what you're getting into with big law. Most of the time, large law firms, and even many smaller ones, really want their associates making a certain number of billable hours a year.
Sorry.
Could we? Thank you. They really want their associates making somewhere around 2,000 or more billable hours a year, which is, by the way, that's full time. If you're putting in 40 hours a week for 50 weeks a year, that's 2,000 hours. So now think about what you have to do to get to a full billable hour. You're going to have to put in more than 1 hour's worth of work to get a full billable hour on average. So you're putting in more like 2,400 hours a year to get to 2,000 billable hours, and that's if you're good. An associate just starting out is probably only billing half of their hours as billable hours. So now you're putting in 4,000 hours a year to get to 2,000 billable hours. It starts to suck at some point. So 80 hours a week for 50 weeks a year sucks. That's why I'm not in big law, even if I could be.
I think it's kind of like, if you know that, okay, you have to be at the top 5% of your class from these particular schools in order to get into this law firm. It's like the law firm is outsourcing their recruitment to the universities. And they're saying, okay, like, whoever you say is the best, those are the people that we'll take.
Well, sort of. They do
for them.
extensively interview you as well. It's not an easy interview process either. It's just more or less you're not even a candidate unless you're a top 10%er. Did I see that Leor Lesser has filed a complaint with the FCC against Patreon and PayPal for antitrust? Antitrust is a very high standard. I would need to see it. I don't know anything about it, and I couldn't even begin to form anything but an extremely skeptical opinion without seeing it. Dustin Rodriguez asks, what is big law? That's a kind of nebulous thing to describe. It would be the largest law firms in the US, maybe even the largest law firms around the world. Law firms with a few hundred or more attorneys, law firms that can bill a total of many thousands of dollars an hour. An example, one of the highest financed divorces that I'm aware of in New York City had a number of attorneys working on a divorce at one time, reaching to the point, I believe they were billing $27,000 an hour. Now, the funny part is lawyers have a duty not to charge an unreasonable fee. And that's not like under some special circumstances or anything. It's not to charge an unreasonable fee. So if in order for that fee to be deemed reasonable, there had to be a lot of attorneys working for a reasonable fee on that case. So I'm guessing they had 100 attorneys or 70 attorneys working on that case to make that $27,000 an hour. Yeah, you got to watch your sleep too, Butters. Yeah, life is more than billable hours. But hey, if you want to chase the green, nobody in the law is going to fault you for wanting to make it rain. And an attorney working, even an associate working in a big law firm, starts at about $120,000 a year. Yours truly has not made anywhere close to that in his lifetime, as far as that in 1 year. So that's the draw. And then there's opportunity from there. It only goes up from there. If you were to if you were to succeed in big law and become a partner, you're easily up into the $500,000+ a year range, very easily, without. And it starts to get easier on you the farther and farther you get up the chain in the law firm, as you can have all of your associates doing that 2,400 hours a year worth of work for you, while you focus on the things that are more important to you and your firm that you're now becoming more of a partner in. That's fine. That's great that they can do that. Certainly, it leads to some abuses, but those abuses get reined in too. I'm not really knocking the big law firms. I'm just saying it's a different world, and if you want to be part of that, that's fine. Good luck. Hey Leonard, my favorite VLC media player. More money, more problems, according to Michael Scott.
So one of the questions that was asked on Twitter was from Chowpup, and he asked any chance that you'd do some sort of collab with the fellow internet lawyer Boozy Badger / Boozy Barrister. And I wanted to sort of expand that question into being, if you could do a collab with any internet lawyer that you're aware of, who would it be?
No, I'm happy to do all the collaborations. I'm terrible at this. I get busy and we get caught up in other things, and Tactical and I have been working together now for 5-6 months on the piracy law firm, and it's going well, and so it's distracting me from these things that I want to do for the channel, as far as doing more things for the channel. One of the things I want to do is interview other lawyers. It would be good both for me and for you. And I think we could do a whole segment on the real, I can't use the word super lawyers, the real superstar lawyers. I don't know, that's probably too close to their trademark too. On the lawyers who are doing a really good job advocating for their clients in their field. I would love to highlight and showcase them on the channel, even if it means me traveling around the country and interviewing them. I think there are a lot of remarkable stories to be told, and a lot of us lawyers get caught up in making money and representing clients that none of us really care about the publicity at the end of the day or telling our stories. But so many of you, my audience and others, really do want to know more about what lawyers do, about how the law works, about how individual parts of the law work. I think the law is becoming so developed niche in different niches that you almost need to have a little bit of a guide for how basically copyright law works, so that when you call an attorney in copyright law, the two of you can speak the same language. My bedside manner is as good as it is because I've developed over many years how to talk to people who don't know what's going on using language that they don't understand. You have to be able to relate it to people. And I spent 9 years and 45,000 phone calls doing tech support, answering the same electronics questions over and over and over again. And that was a lot of experience. That was a lot of good experience. It was boring, and I hated almost every minute of tech support. But at the same time, I learned how to be patient with people asking the same question over and over again and needing to hear different ways of explaining an answer so that they understand at the end of the call. They understand what's going on.
we had a question about if you ever worked in terms of criminal law.
By accident, I've worked in criminal law twice. Once was my accident and once was somebody else's accident. The first time it happened, I was... so remember a few weeks ago we talked about officers of the court? I'm an officer of the court. So a police officer is an officer of the law, or a military officer is an officer of the military or whatever. I'm an officer of the court. I do the judge's bidding. But the way the system is set up, I'm meant to represent clients before the court. That's me, Officer French's purpose. Well, the reason I'm saying Officer French and Officer of the Court is because I one time got a letter from the court that said I was ordered to appear in a case that I knew nothing about. And it was a case that was being assigned to me. Someone had been accused of possession of heroin, and I was the attorney that was appointed to go and represent them. And this had never happened to me before. I had heard this could happen, that there could be, like, your county could cycle your local attorneys through the public defender's office as substitute public defenders. No, that's not actually what was happening here. But I did. I contacted my client and I had him sign an agreement, and I showed up and I talked to the other attorneys there, and I was like, hey, I don't usually do this. This looks like a really easy case. It's just simple possession of heroin. It's like his first or second offense in a long time. So, you know, what do you do? And they said, oh, I would just ask the judge if you could plea him out to fines and costs. And so that's what I did. I walked in and the judge said, you know, oh, is this Mr. So-and-so? And she looks at me. And who are you? I was like, oh, I'm Leonard French. I received this letter. She took the letter from me and she looked at it. She gave it to her clerk. How did this happen? Mr. French, let's proceed. Is your client prepared with a plea? And I said, yes, we would be fine with pleading to fines and costs on this, Your Honor. The man has no prior record and is no flight risk. He has a family and a job, and it would just be good for everybody if he had. And the judge said, fine, fines and costs, have a nice day. And I walked outside and reintroduced myself to the attorneys who were out there who confirmed, you know, oh, you did a good job and all that. And I said, oh, thank you, thank you. Oh, what's your name? I'm Leonard French. And they, you know, oh, I'm Alexandra French. And then it hit me. I'm Leonard French, and they just typed in French and got an attorney, and it was meant to go to this Alexandra French, who was the public defender for the county. Instead, it went to me, and I ended up accidentally representing one of her clients. But it was fine, because actually I did exactly what she wanted me to do. The second time was my mess up. I was representing people in traffic cases. Traffic cases start with TR. And so MJ, you know, 2017 TR, something. Well, I got a traffic case and they called me, you know, yada, yada, this is what happened. Okay, I'll take the case, whatever, sign here. This one didn't say TR and I didn't notice it. It said CR. Criminal. Yep. And I'll tell you this story because this is a terrible, terrible story. There was a hit and run collision. Someone in a red Suzuki sedan had hit a driver from the rear, had bent their bike rack or whatever, no bike on it I don't think, just a bike rack, had damaged their bike rack and had driven off. The person who called me though was the driver of a silver Suzuki SUV who was being accused of the hit and run. Well, I spoke to the prosecutor and I filed an alibi, and when we went to go to the what would have been a status conference before the trial, the prosecutor came at me very hard and said that he was going to do everything they could to get our alibi thrown out, that they were going to oppose our request to have Google validate the location of my client's phone, which was hours away at her home where she lived with her family, and there was no way that she could have been the red Suzuki sedan. The model was different and the color was different. There was no way. But this prosecutor insisted that he was going to destroy me on this, going to destroy me in the thing and going to destroy my client, and all we have to do is pay $500 to get out of it. And I will admit that I weighed this very heavily in my mind, and I took this to my client, and I could not help but recommend that we pay the money and have the case over, because even if we won, I was going to need more than $500 to defend the case. Any further than that, going to a full-on trial with a jury and everything. So they won. So we paid the money and all that, and the thing was dismissed and all that. And all this is public information. None of this is secret. But I'm super pissed off that the prosecutor was so willing to go after an innocent person that was clearly innocent and very easily proven innocent just because they wanted to win. I won't. Oh, sorry, David. I accidentally clicked hide. Here, I'm sorry. I'm gonna post it. I'll post it. What you said.
What you say? Hey guys.
See, now I have to forgive Blackleaf and give him $10 back because I just did the same thing.
No, you only hit.
Well, you didn't ban him.
Blackleaf banned him for 300 seconds.
Yeah, and the prosecutor guaranteed that the guilty person got away with it because now no one is prosecuting the silver Suzuki sedan, or red Suzuki sedan, that actually committed the hit and run. All I can think of, the way this happened, is that the eyewitness actually got the wrong license plate number, and this everybody else went through with it. To play devil's advocate and defend the victim/witness who got the money and basically got this whole thing prosecuted against the wrong person. They did pick my client out of a lineup, but to me, there's a 1 in 8 chance that even a wrong identification would be my client, because it's not like there's a way to, they're going to pick somebody in the lineup. They've been primed that the person's in the lineup. So, conspiracy theory, the prosecutor was driving the red Suzuki sedan. There you go. You got it.
Oh, shoot. I think we figured it out, guys.
Yeah, case closed. Ah! Shit, did I just disconnect myself? No, I didn't. Yay.
You okay?
Yes. I swear, I'm not intoxicated. I sobered up just for this. What was my quickest copyright case? Some of them I can't talk about because we've settled things and I'm bound by agreements. So I'll just speak ethereally. I'll speak in general terms, in anonymous terms. There was a large, I feel bad about this one. There was a large television network. I can't really say anything more about, because I can't give you any information that would allow you to guess. There was a large television network that held a song contest. They all do, so I don't think there's a problem here. And one of the songs was an original piece of music, but it was copyright infringement on my client's song, and we successfully received a license fee for that song. Unfortunately, there's the second half of any of those things that now, even though the artist that committed the copyright infringement did commit copyright infringement, it didn't really make anybody's life a whole lot better. I haven't necessarily heard that things worked out for them after paying the licensing fee. It sort of has this secondary knock-on effect where someone's feeding back, Brandon. It sort of has this secondary knock-on effect where you've prosecuted someone for copyright infringement, but someone found out about it. In other words, the major television network found out about it, and they're not necessarily blacklisted, but it's not like there aren't a million people who haven't committed copyright infringement who are more than willing to write a song or something. So it probably hurt that person's career more than we meant to. I feel really bad about that, but I don't know what to do. I had to advocate for my client who had their song stolen. And to be perfectly clear, the person wrote a new song. They just wrote it with my client's lyrics. So it was definitely copyright infringement, but it was also them attempting to write something new and good. It just, they didn't understand that they were committing copyright infringement. It's very important to understand copyright.
Well, was it one of those situations where they looked at it and they're like, oh, yeah. Like the lawyers were like, you should probably settle this.
It was an open and shut case. Without revealing any confidential information, there's a rule of evidence, federal rules of evidence, that say that, so everybody's heard of hearsay. You're not allowed to use sort of the statement of a third party to prove something. Very oversimplified. That's not hearsay, but that's my layman's explanation of it. So you couldn't normally be able to use the opposing party's statement against them until you got to court, and even then they'd have to admit something on the stand. So you'd bring up their statement from outside of court, and someone would say, oh, that's hearsay. Well, there's an exception to that. An admission by party opponent is not hearsay and is fully admissible within the rules of evidence. So what do? You write to them and you say, hey, we saw that you used our song. That's great. Oh, tell us about it. What happened? And you don't let them know that you're upset. You don't let them know that you're going to sue them. And you let them write back and they say, oh yeah, that was awesome. We love you guys. We did this and this and this and this and this and this and this.
And that shows that they were aware of the art. Yeah.
It's kind of an open and shut case then. Should number plates, should license plates have a check digit? Hugh and Marshall, that is a wonderful suggestion. If they had a check digit and it had to comply with, you know, like the summation or some of the digits or something had to add up to a check number through, that would be perfect. Then you would always know that you had at least a valid plate number. At the same time, it wouldn't really stop anybody from making up digits on plates. They would just go find another plate and make sure that they used a number from another plate, or they would, you know, it would definitely allow you to pick out certain illegal plates, but I don't necessarily think it would solve the problem for very long. It would just create another fringe where people who didn't understand the crime could get caught. But
I mean, you'd have to keep the math secret as to how the check digit is generated, and it'd be a whole nother complicated mess.
Yeah, most of the time a checksum is public because you want everyone to be able to check it on both ends. So even the checksum for a credit card is still known because you have to be able to check a credit card number before you feed it to a credit card company.
Well, there are ways, that's how public and private keys work. There are ways to check if a checksum is correct without actually knowing the equation that was used to generate it.
And here we get into the information security theory, which I am not quite there yet. Actually, believe it or not, the next thing I want to do with my career is the Certified Information Privacy Professional certification. If I can succeed at taking business in information privacy and then eventually information security, I think I will be set for the rest of my life. Who is my favorite lawyer? You know, I honestly don't really have a favorite lawyer, but if I was forced to pick one, it would definitely become Vinny from My Cousin Vinny. I forget what his last name was. Vincent Gambini, I think it was. That movie is one of the most accurate fictional movies about the legal world, and it's a lot of movies and shows and things have only become more unwatchable or less watchable when they have a law slant or something. Now that I'm a lawyer, My Cousin Vinny got better. I understand more of it. I understand the subplot of the judge and everything. If you remember in the beginning, he goes to meet with the judge and find out if the judge is going to let him represent the cousin and the cousin's friend. I forget their names. And he gives him this big law book and tells him to follow the rules and everything. And I never really understood that scene until I became a lawyer. Well, what do we talk about at the beginning of the stream? Vinny's not admitted in that state. He's admitted in New York, not Alabama. He's not a criminal attorney, a criminal defense attorney in Alabama. He has to get permission from the judge to represent in Alabama. So he has to convince the judge that he's an experienced defense attorney who can easily learn Alabama law and stay up on all of it and he in the process he lies to the judge and tells him that he's like two different other people, and the judge almost catches him, except that Vinny's friend judge in New York calls and gives a story that passes muster with the Alabama judge, and he gets away with it by the skin of his teeth. And if any of us did that, by the way, and got caught, we'd basically be disbarred. You're not allowed to lie to a court, not allowed to lie to a judge. And I mean that as in, that's the real not allowed kind of thing. So the whole time he was really flirting with losing his whole law career if he was ever caught lying to that Alabama judge. That makes the subplot much more interesting to me.
I have a more generic question.
Yes.
So 2018 has been a big year for you. So do you think, like, are you happy? Are you satisfied with how 2018 has gone for you? What were the biggest surprises for you?
Oh, 2018 was a roller coaster, but it ended on it was a good roller coaster. You don't normally end at a higher level than when you started in a roller coaster. So 2018 started, let's see, I was taking fewer and fewer piracy cases because I wanted to focus more and more on the channel, but we were suffering from the adpocalypse, like, I don't know, round 2 or 3 of the adpocalypse, and still growing on Patreon and such, and still trying to sustain a level. And then in the beginning of 2018, we moved Brandon out here. And in the middle of 2018, I hired Tactical for the law firm. And throughout 2018, I was talking to Kaley. And I met Kaley for the first time in October. And now I'm here in Scotland with Kaley in December. So that's pretty cool. And we've taken many more cases now that Tactical is helping me handle piracy law, excuse me. And I'm now admitted in the Western District of New York. I'm now admitted in Colorado. We have actually beat a couple of these copyright cases, and we are looking forward to beating we're working on beating a few more. I don't know. I don't want to jinx myself. You know what I mean? I'm not going to talk about ongoing litigation.
Yeah.
And we are just doing much better. I still have lots of problems to solve, but those are being solved slowly. Oh, that's right. I also bought LawyerSimulator.com, registered the Lawyer Simulator trademark as an intent to use trademark. That was denied, but I have another 5+ months to respond to that, and I think we can overcome their concerns. They mostly think that Lawyer Simulator is generic or merely descriptive, and I think it's stronger than that, but even if it is merely descriptive, you're still allowed to generate secondary meaning there, so I'll just have to, start selling products with Lawyer Simulator on them and have that secondary meaning get generated. It's fine. We own LawyerSimulator.com, so I'm not too worried.
Hey, we
Someone's gonna
just
have
sell a T-shirt and boom, done.
Basically, yeah, but that's not the category I want. I want the category of software development or video games or something like that. So I have to release something that fits into that category first.
You got your silver play button.
We got our silver play button on December 15th.
It came very, very close to when you were leaving the state, and actually the country even.
Yes.
I thought about bringing it here, but I didn't want to lose it or break it or get it scratched or anything.
It's quite large now. They've changed the way they do them.
Yeah, we did. We hit 100,000 subscribers, and we got the silver play button. And now that we're at 105, I'm like, totally forgot about it.
Hey, I even was there when you hit 100K.
Yeah, and Kaley was there for the day that we hit 100K. That was really cool.
And I remember you were saying, like, I don't even care if we dip back under 100 after we hit 100. I just want to hit 100. Like,
well, it was my goal.
Like,
my goal was to hit 100 when we began the YouTube channel, and we hit the first, I don't know, 10,000 subscribers. My goal was to hit 100, and I promised myself that I was going to work towards 100 no matter what. And then I promised myself that I would not make any further decisions until we hit 100, and so I wasn't forcing myself to go past 100. That's what that meant. It meant that I was setting a moderated goal for me. I remember we were talking earlier about extremes and how like I wasn't allowed to make mistakes. Well, this was my way of saying you can push for something, but you're not bound to it. If you don't like it when you get there, you can stop. And I still like it. I'm having a great time. You guys are wonderful. I actually missed you. That's why I'm here talking to you. Not just to do a live stream, but because I want to actually interact with my audience.
Do you want to, since we missed it on Sunday, do you want to talk about the book?
Yeah, we can talk about the book, but I haven't listened to anything more. Since I've been with Kaley, I haven't been reading the book.
So what did you get? Are you still just on chapter 9 then?
Yeah, I'm still on chapter 9. I haven't gotten any further.
Oh, okay. Well, we can at least talk about chapters 1 through 9, right?
We can. Does our audience want to talk about the book?
I don't know. I mean, the people in the book club seem to be interested, but I don't know if they're here. If these
why don't we
people are
talk about the
interested.
book club on Sunday? We'll make room for it on Sunday.
Okay.
I'm also not prepared. I didn't really think about the book or any part of what I want to talk about with the book.
Just a suggestion.
Sure. What other questions do we have? The book that we're talking... Go ahead.
Oh, Linda Bueller was asking if there was an online like vault or time/date stamped portal where you could submit original lyrics or poetry or original works, so that if later you needed to prove ownership or the origin of the material, you could.
No.
And I feel like that's kind of what the Copyright Office does a little bit.
Well, sort of, yeah. If you it costs $25 to $35. I think it's $35 now. And you have to follow their procedure and everything, and it takes about 3 months to get your registration. But yeah, you can deposit a copy with the Copyright Office in the form of a copyright application, where you would have to pay a fee of $35, I think it is, possibly more under some circumstances, depending on how much you're registering. I believe photographers can register an album, musicians can register an album as well, but keep in mind that then the copyright infringement is the whole album, and you're suing over the whole album rather than any one song. You can sue over one song, but you're only going to get one remedy for the album. The point of all that is not to get you, not to prove that you have a valid copyright, but to prove that you filed a valid copyright at a time. That's about all that means. You still have to prove copyright ownership. When you go to court, you can still have your copyright challenged in court. A certain copyright claimant that we dealt with last year did this, registered a copyright, and then said, "Oh, I own a copyright now." No, you made a valid copyright registration. That doesn't actually mean you own anything. It doesn't usurp contracts. It doesn't create things out of thin air. It's just more or less the first step before you sue. You must register your copyright before you sue. You can register it at a particular time, and yeah, that date would probably be meaningful to a copyright lawsuit, but you have to decide for yourself whether it's worth that effort or not. Other ways of doing it are like archiving the file to some place, or having something notarized. Probably having something notarized would be a lot easier, because the notary is an official legal witness. They'll timestamp it and date stamp it for you. That might be easier. Just go to your local notary and pay the $5 for a notarization on something. What's my favorite video game drama this year? Oh God.
Soldier Boy.
Fallout 76 is currently the biggest debacle, I think. I'm still sending letters from people, by the way, we've sent out about, I don't know, 8 or 10 letters from people just that we've been hired to send. And then I don't even count how many of you are actually sending them through the website, because I don't believe in tracking that. We didn't want to have to put privacy notifications or tracking notifications or whatever. So the most tracking we have is literally just tracking page loads. We're not attaching them to people or IP addresses or anything. So I actually don't know how many of them have been sent, but I'm sending mine. I haven't sent it yet, but I'm going to be sending mine in the new year, and we'll see what Bethesda says. I'm anticipating that I'll get my $60 back, but we'll see. I have not seen the rum drama. I saw the title, I saw the video title and thumbnail, but I have not seen the Nuka Dark Rum controversy yet. I have to read through that one, or watch that one. David McGuire says, what is the most aggravating piece of misinformation spreading about copyright and the internet? The misinformation about the DMCA takedown process is really, really bad. It's, the damage isn't necessarily, well, that's kind of the problem. It's death by 1,000 cuts. The DMCA process, like I explained before, is geared towards keeping content hosts in their safe harbor. So that means that it's not focused on the claimant, and it's not focused on the recipient of the claim or the owner of the original material. So the most aggravating piece of misinformation about copyright that I see people spread around the internet is that YouTube is the problem. And certainly YouTube is part of the problem. I'm not exonerating YouTube in any way other than to say that they are not the creators of the DMCA process, and that they don't necessarily have anything they can do to make it easier for you. They're pretty much just obeying the DMCA takedown process. When they receive a claim, they process it. When they receive a counter notification, they process it. They have to obey these laws if they want to remain in their safe harbor. Someone mentions the no copyright intended, or this video is fair use. Those are fun. That doesn't really mean anything, and it can actually have the opposite effect. If I saw someone put up of it, let's say that I'm prosecuting someone. Let's say that I'm representing a plaintiff prosecuting someone for putting up a copy of a movie, and in the description they said, no copyright infringement intended, this video is meant to be a fair use. I'm going to actually have an easier time making my case against the fair use, because I get to say, oh look, you knew what words to look up. You knew you should look up copyright fair use. You even said so in your description. Hey look, copyright fair use. So if you had simply read more about copyright fair use, you would have known this is not a copyright fair use. I'm going to say you did know that it wasn't a copyright fair use, and that's why you put the message up. So I'm going to have an easier time showing that your infringement was willful, because you put up a no copyright infringement intended, this is a fair use notice. Tarkov is up there. Tarkov made the bunch of false claims against, what was his name? Eroctic.
Eroctic, yeah.
And the trouble is, Eroctic, I believe, is from Croatia. And
Correct.
Tarkov is from Great Britain. And is a Russian company registered in Great Britain. So the trouble there is that there's going to have to be some kind of lawsuit in a different jurisdiction than I would normally recommend. So it's an interesting one, but not as interesting to me as the Fallout 76 debacle.
Someone is also posting there's apparently another problem with Fallout 76.
With the Nuka-Cola Dark Rum or something else?
Like a holiday emote that got them in trouble with Europe.
There was a holiday emote DLC priced at $24, then immediately on sale for $12, which got them in trouble with the EU. That's a no-no.
Yep.
Do you know what the no-no is there?
Well, in our consumer laws, you can't promote something as on sale if there was no base value of a price. So if I sell something, I believe, I'm not 100% sure on this, but there has to be at least a few days in which I sell it for a certain price before I'm allowed to call it on a sale.
Okay.
So I can't just perceive people. So that's also one of the reasons why our Black Friday sales don't really seem to be that spectacular, because we can't really play around with the prices of originally priced this and then pretend it's a bigger discount.
Oh, yeah. Well,
like they might do in America.
Well, technically, yes. Well, they do it in America and they get away with it in America, but it is still technically somewhat illegal to increase a retail price beyond its original retail price just so you can then say we're giving you a bigger discount.
Yeah.
That sounds like a misrepresentation that the FTC would want to look at, but here's the other half of that. You may not be aware that we currently have a political situation in the United States. Something that's been going on, not just under this political administration, but under the last few political administrations, has been sort of a systematic defunding of some of our agencies, like the IRS and the FTC. These agencies require manpower. They require employees, men and women on the ground doing the freaking job. And, well, it turns out that people don't work for free. Well, unless, of course, you're a furloughed essential worker under the current government shutdown, but that's not what I'm talking about. And I lost my train of thought. And these agencies are basically further and further and further understaffed, to the points that some of them aren't doing 100% of their job, or sometimes even 70% of their job. And there's currently some concern that we're going to have a problem with tax revenue in the US if this keeps going unchecked, because the IRS is not collecting as many taxes as they used to. Even though they're, for the same rates and everything, adjusted for the different tax rates and all that, the IRS is not prosecuting as many tax dodgers and tax cheats and such as they used to, because the IRS literally has fewer people to do so with, because the IRS is getting lower budget from the federal government. So that's a problem with enforcing, say, a trade problem like misadvertised prices.
I just wanted to mention really quick, my least favorite thing about, or my least favorite misconception about copyright is the word copy strike.
Which is also now my favorite word. I'm letting it, I'm backing off of it because I don't want to annoy too many of you, but I love the word copy strike. It's my favorite word. It's an absolute, my favorite word.
What I love is that we had a legit conversation of what the past tense of copy strike is. Is it copy struck copy striked. I don't know if chat wants to join in and say what they
Copy
think.
strike? I like copy strike.
I do not know if the IRS is working during a shutdown. I can tell you that the tax attorneys I spoke to are working during the shutdown, but those were private tax attorneys and not... the tax attorneys I spoke to were actually working on Christmas because they... Their explanation was that they have deals to get done before the 31st, and there just is no time to waste. Copy stricken.
Well, that's like the advert pass test, right? I was copy stricken.
And one more thing, because I see some people commenting about the tax code. You can go and read some articles on this. I am not convinced that this is just a conspiracy theory. I believe that it's fully possible this is a completely real theory, and maybe Snopes has something to do with this. Maybe one of my staff could quickly look this up. Is it true that the tax code is complicated in order to keep consumers or regular citizens from doing their own taxes? In other words, is it complicated because H&R Block and TurboTax and everybody has lobbied for more complicated tax laws so that they have to be done by a third party and get paid, for that?
Filing taxes could be free and simple, but H&R Block and Intuit are still lobbying against it.
Yeah, I'm seeing legitimate news sources that confirm.
Yeah.
So yes, I believe this is true, and so you have to understand, we live in the U.S. is a capitalistic republic. We are not a democracy. The lobbyists who have the most money get the most time with politicians.
Yep.
So let me be frank. Not Kevin Spacey. Let me be a different kind of frank.
Why? Why even make that reference?
Because it shows that I'm up on the things, and I saw the thing yesterday and it was weird. He's also a phenomenal actor. By the way, that was acted phenomenally well, but was so creepy.
We have to separate the art from the artist.
I have to separate the art from the artist. He is a good artist. He is a terrible person if what he's being accused of is true. Anyway, let me be frank. This is the same problem we have with the copyright law, the DMCA, YouTube, and all of that. How many of you are paying your lobbyist to go to Washington and talk about problems we have as creators? None of you, not a single one. I would bet money that not one of you contributes a single dollar to anything that is considered a lobbying effort in the U.S. federal government in favor of better copyright laws for creators. I'm not blaming you. I don't contribute any money either. Do I call my congressman and say, oh, I want better copyright laws? No, I call my congressman and say we shouldn't be detaining children. So yeah. Maybe I should be calling Congress and lobbying for better copyright laws on your behalf. Maybe I should form a organization to lobby on behalf of creators before Congress and before whatever entities can help make a difference. We are in contact with several people from major organizations around the country that would be basic lobbying organizations, mostly because they like our channel. We've received some nice letters over the years, even from copyright plaintiffs, even from people who don't want the copyright law to be better for creators. They want it to be better for content owners. Those people still like us because we toe the line down the middle and aren't extreme in any way, and want to see people educated and want to see the system grow for us all and not just for any one person's greed. So yeah, we were thinking of some kind of YouTube union or some kind of advocacy organization. I'm still thinking of making Lawful Masses a nonprofit, but I've got to work on the structure of this organization. If I had to fantasize for a moment, we own a few domain names. Lawful Masses, of course, would be one way that we could become an advocacy organization. I wanted to create a YouTubers Union round about the same time that Jorg Sprava did his YouTubers Union thing, so I backed off because I didn't want to take even a single ounce of attention away from Jorg Sprava. If he's not been successful yet, or maybe if we can work together and do a thing, I would be happy to be a representative for YouTube creators in Washington. I would want to get paid for it. I don't mean a ton of money. I don't mean that I would need millions of dollars. But I would definitely want to get paid a respectable amount of money, so that I could see my Kaley, so that she could see me, so that I could, you know, have fun with my dog, so I could make more videos for you, so I could live. But I'd be willing to represent all of you. I'm 100% open to the idea. In fact, I'd love to have the opportunity to make a formal application to you and have you give me feedback in that sense. Darter 9000 said they'd love to help with the C4 or C3 efforts. That's great. I probably do need help with that. Tactical has done a lot of preliminary work, and I need to pull the trigger on it. And you know, I'll probably be doing that sometime in the beginning of the new year. It's just been a roller coaster, like we said.
It's been a year, yeah. It's been a year.
It's been a year. So if I had to fantasize, we would start two companies. One would be Lawful Masses as a legal education, public service legal education organization. We would start a second company. Right now, I own a website own a domain name. I mean, it's not set up as a website, but I own a domain name that Brandon actually recommended. He gave me the name, Benefaire, Benefaire. So it's like, you know, pseudo French or whatever. But Benefaire, you know, for the good of the profession or something like that. And that would be more like the advocacy organization. And maybe there'd be a third organization where we would actually take on clients in a reduced fee public service law firm capacity. Between these three organizations, I would obviously be able to hit my target and pay for my student loans. And in 10 years, I'd be student loan free, and then the sky's the limit as far as, you know, where we go from there. Organizing all of this, running all of this, I have realized that I can't do it by myself. So I'm going to need not just me, not just Tactical, not just Brandon, and not just Kaley, but probably even more help than that. But it looks like we need it. And if somebody was able to do a good job, I think you guys could really use it. I think it would actually have a noticeable benefit for you. I mean, yeah. Who is the spokesperson when Patreon takes Sargon off the air?
There are none.
There are none. Now here's the problem. How many of you want to be associated with an organization that would defend Sargon? That's a tough question. There are many of you who wouldn't want to. Patreon doesn't want to be associated with Sargon, and there are probably many who agree with Patreon. So it's a tough question. What happens when we take on representation of somebody, but they've lied to us, and we end up getting deep into a case, and only then do we find out that we've wasted all of our money and they can't pay for it? How do we deal with that? I have a ton of questions about risk, basically.
Yeah.
Gonna have to get insurance. I don't currently have insurance because I don't really, as much as I do these copyright things, I don't really face too much personal risk in these things. Well, the further and more litigatory and all that I get, the more we're gonna have to have insurance for these things, because you never know when something's gonna go wrong. It's not just me anymore. It could be one of my employees or staff members that does something, and how bad would Brandon or Kaley or Tactical feel if they made a mistake and it shut down the organization? I'd rather have insurance when we can weather the storm. So this takes money. Sorry, So we're going to have to ask for donations, and that means I want to be a nonprofit before I ask for real levels of donations. Heck, even if so what happens if you disagree with Patreon or something? We could start our own Patreon, but then that means we have to deal with the problems of payment processing and all that the same way. And what if MasterCard comes to us and says, well, it doesn't matter that you started your own Patreon, we're still not going to process for you because you have Sargon now, or something like that. There's a ton of problems that have to be overcome before we can really serve the community the way we want. And then what happens when we accidentally can't serve the community the way you want, and the community turns on us? Have to be able to weather that too.
So, a couple of things. First of all, we would have to be something kind of like the ACLU, who doesn't argue politics. They argue the law, Yeah. Like, it has to be a situation where it doesn't matter if you're a Democrat or if you're a Republican. Copyright law is an important part of our ethics.
Yes.
And we have to make sure that it's up to snuff with all the situations of a modern century,
But you understand their ACLU is currently much more controversial. Even though I think they do a great job, they're more controversial than Leonard French and Lawful Masses are, and I have to be prepared to deal with that.
Yeah, no, I mean, I'm not saying that the ACLU has never argued politics. I'm just saying that, I think that was...
I agree with you.
One of their founding principles was that they just wanted to defend free speech no matter who it was.
Right, and they made an announcement the other week that I got pissed off at, and I'm no longer interested in working for the ACLU. Gender politics should not be brought into the ACLU. I do not understand this, but they started the gender politics thing. So, nope, I'm out. But, and the same thing, gender politics would not be part of Lawful Masses or Benefair. But,
yeah, definitely. The other thing was we definitely would have to raise some kind of a starting fund. If we wanted to do something like this, we would have to start a GoFundMe, say, this is how much we need to get started. This will pay, our employees for a year. This will pay our, this is all going to be considered charity donations. We already have the organization set up. Yeah. This is what we're doing. So we have to pull the trigger, and then we need to raise money very quickly from that point. So it's going to take a lot of work.
Or at least the corporation or the company has to have very low operating budget until we have things to operate on.
Yeah.
Definitely keep in mind that we could talk to the EFF. They are a different advocacy organization, but they would be very close to what we would be looking for. They are not a union or whatever, but they are an organization that does occasionally represent in a case where someone needs more than just a regular amount of representation or has more than just an individual claim.
I just want to quickly highlight Milky Bar Kid, his last comments a lot. That just made me giggle.
Am I trying to cross the road? No, I am the Duke of Wellington.
I wanted to read this information about the IRS thing really quick, the tax lobbying, because it's really interesting. Do you mind if I read that really quick?
Go ahead.
So Intuit spent more than $2 million, and H&R Block spent $3 million. There were 13 private tax preparation companies that were lobbying for the Free File. They call themselves the Free File Alliance, and they're lobbying for an act called the Free File Act of 2016. And I'm not going to read this word for word, but basically they were trying to, quote unquote, make it easier for people to file by setting up their own free filing system that would also bar the IRS from having their own system. So their point was to restrict the IRS, make it so the IRS can't have a free file system on their website, and require them to link to the 13 Free File Alliance websites, which would then, of course, try to sell a paid filing system to the person who went to the website. I'm not sure if this bill passed or not.
I don't think it did. There is a Free File website, or a couple of them. And so I used to run a tax clinic, believe it or not. One of my best courses in law school was federal income tax, and I really wanted the pro bono award at my graduation ceremony. So I did 60 hours of pro bono legal work at the tax clinic, and then I ran a tax clinic for 2 or 3 years. I think I attended it the first year, and I ran it the second 2 years. And although I'll never do that again, it was a good experience. And the reason why I wouldn't do that particular clinic again was because I didn't receive the amount of support that you would expect to receive in a nonprofit law advocacy organization or legal representation organization kind of thing. But it was a good experience to represent people, or rather to do their taxes. We would do several hundred tax returns. By the end of the thing, though, all of my help left, and I was doing most of the tax returns by myself. And I got very good at them. I can do a complete income tax return in less than 10 minutes, but, there were several hundred to do. So Blackleaf says he supports Sargon and the marketplace of ideas and dumped my Patreon donations in protest, but I don't want to see my favorite copyright lawyer and friend get hurt. Merry Christmas, Leonard. Here is hoping a new year is bright. Thank you, Blackleaf. So I'm not in any danger of losing my Patreon support that I know of. We've had a couple people cancel their Patreons, and that's fine. I'm not upset about it or anything. And we'll be happy to use other Patreon-like subscription services. We're waiting for YouTube to turn our subscription service on there. There's Subscribestar, but unfortunately they seem to have some payment processing issues. There's Sponsus, but Cerulean is our developer, or rather we are honored that Cerulean chooses to develop for us from time to time. And I don't know that Sponsus is going to be off the ground quick enough to serve anyone anytime soon. It's
technically,
Go ahead.
I'm sorry. Technically, we had it set up in a state that would work for your channel.
Yeah.
But the issue was the payment processing, and it
right.
was.
Well,
it
we
was
could start it. We could start a limited trial run of something or other. The trouble with these things really isn't to do with free speech or isn't to do with Sargon or anything. It's to do with the payment processors. Whether it's Patreon being overly protective of its ability to operate and, finding the one or two bad apples from their perspective that they think are bad apples and getting them off the platform so that their payment processors get off their back. So the payment processors get off Patreon's back. I don't know exactly what's going on there, and I suspect that we would run into the same problems. So this has to be somehow overcome. Now, that would mean that I would have to get much more familiar with these fringe cases that everybody's upset about, and if nobody's going to subscribe through our service because we don't support Sargon either, well, that's a problem. I need to figure out what's going on there and address it, and so it's a difficult situation. You want to support free speech, but then these platforms are not technically free speech platforms because they aren't. So freedom of speech, there's two ways to interpret it. There is the concept of freedom of speech. Let's back off of that for a moment and talk about the United States Constitution First Amendment. That only applies to government and government actors. That's not Patreon, that's not Facebook, that's not YouTube. Even if they have a monopoly, that's not what we're talking about. You are full of cat hair. Yes. Oh my God. I wish we were in 4K right now so you could see all the cat hair. But then you see the zits on my nose. The only way that you would need there to be a law, like an anti-discrimination law. Currently, you can't discriminate based on sex or sexual orientation or ethnicity or race or disability. In many cases, you can't discriminate based on age, etc. None of that says you can't discriminate based on political belief or based on whether you smoke or drink alcohol or smoke marijuana. Those are not protected classes. And If Patreon doesn't want to allow guns, or doesn't want to allow Sargon, or doesn't want to allow people who smoke cigarettes, they're allowed to do that. I don't agree with their decision, but they're allowed to do that. And you saw this earlier this year. Intuit payment processing stopped processing payments for gun purchases. They didn't tell anybody either. The businesses that used them literally just were, one day they didn't have the ability to process funds. You've seen it with Sargon just getting kicked off of Patreon or whatever, or getting kicked off of others, certain other people getting kicked off of platforms. Now, some of that's deserved. I don't know all the circumstances with Milo and with Sargon. They're not my favorite people. I don't follow them, but that also means that I don't know what they did or said that pissed off Patreon or got them kicked off of a platform. I'm not saying they deserved it. I'm just saying I don't know the backstory. So it's a tough situation. And if we were going to start an organization to advocate, I'm going to be advocating more for the core creators and for the people who are making fair uses, rather than the people who are primarily making waves. If you make waves, but your primary thing is some sort of creation, that's fine. My policies would be closer to that. But you understand, you start to see how difficult this is. It goes straying from this line in any way screws the whole thing up. We met at the Roadworks. Yeah, how'd you know? She ran over my friend. It was a poor, innocent road cone. Just gone, life cut short. But our eyes met, and it was not the same. What we need to do about the Patreon thing, people who are upset about Patreon should find or start an alternative. Is there an alternative? I don't know. Good luck. You got to make one. It's not easy. This is real life. Sorry. Yeah, I haven't seen what Patreon cited, but my understanding is that they wouldn't cite stuff. I don't really understand what the problem was yet, but no, those are all good points. Y'all toilets be talking shit. I get it. I get the sentiment. I don't know enough about it, but it does. It seems to be a bit arbitrary. It seems to be a bit unconnected to the actual things. I don't know. No, we have a bank account. Even the banks can discriminate against people. Banks are private entities too.
It's so stupid. Like, we got into it last year, and it's so dumb. And I've had so many people talking to me about, oh, well, I know sex workers that use PayPal and Stripe and Square, and they don't have any problems. Yeah, because PayPal, Stripe, and Square don't know that they're sex workers.
Yeah, once they find out, they'll have a problem. Ewan Marshall says, could it be tortious interference of a contract? Arguing that the payment processors are interfering with the contract between Sargon and Patreon. That's a clever idea. I don't know that will survive a motion to dismiss, but if someone wanted to do that, it would go like this. You would file a complaint, you would argue probably in state court, unless it's through diversity jurisdiction in federal court. You would argue that that MasterCard or whoever interfered with your contractual relationship with Patreon by having you removed for whatever. I don't know that succeeds. It sounds clever, but it doesn't mean it automatically succeeds or anything. That would be an avenue where you could possibly get to a stage of discovery where you may be able to ask MasterCard for information about their communications with Patreon about you. And you may actually get those in discovery. You would have to survive a motion to dismiss. It's an uphill battle, but hey, a filing fee is $400, and you are kind of on the hook for filing fees if you don't prevail in a copyright action, but only if the opposing party prevails would you be on the hook for their fees. It's a good question. You'd want to hire an attorney for that one.
The main issue here is that Patreon is actually not admitting that it's the payment processors that prompted this move. Somebody, I don't know if you saw the video where the guy called Patreon and had a transcript of his call with the woman, but they're basically saying, no, we're banning him because we don't agree with that kind of content, and we go on a case-by-case basis through all of our people and check if their content violates our terms. So they're not admitting, if it is an issue with a payment processor, they're not admitting that.
Bo Stoker had donated $10 and asked about YouTuber Law filing a formal complaint to the FTC for collusion over the Patreon, PayPal, Subscribestar issue. He was looking to others to help spread the word and other lawyers to help bounce stuff off of it. I will go watch the video. I just found out about it on this stream. I have not seen it and don't have an opinion about it. I would need to hear the argument. I do not know what the trade issue or trade law would be. Am I disturbed that Patreon and PayPal and Subscribestar ban people over their viewpoints? Yeah, I'm concerned about that. What would be the legal argument? I'm a copyright lawyer. I don't know what the legal argument would be there. I would need to study it. I'm perfectly capable of figuring it out, but I'm just not familiar with it right now. Sorry. I don't know what you're talking about with which free market, but the U.S. is supposed to be a regulated market, but it's supposed to be a minimally regulated market, which is about as close to a free market as you could possibly get to in a practical world. Otherwise, a true free market would be anarchy. How would you... So if you wanted to have a free market without any regulation, that wouldn't work. You need to have at least a regulation that establishes a medium of exchange for a market to exist, right? So that also then means establishing some kind of enforcement of that regulation and some type of enforcement for violators of the principles of the free market. So people who cheat the free market are not participating in the freeness of the market, they are cheating it. So I don't think you actually have a free market in the anarchy sense. I think a true free market does actually require regulation. That does not make it not free. It needs to be the commerce that is free to be. In other words, there are no limitations or no regulations on the commerce. It's regulations on the market to allow the market to work. Anyway, what are we going on here? 2.5 hours. How are we doing? Let's wrap this up here. Does anyone have any final good questions? H3H3 update? Philip DeFranco liked one of my tweets the other day. That's about as close as I get to an H3H3 update. And yes, I know he's not from H3H3. That's the joke. Yeah, there's a market where everyone's free to compete, as opposed to a market where, power dynamics govern instead. Yeah, well, you agree with me on the free market principles. Thank you very much. All right. Let's see, how long have we been going? Yeah, 2 hours and 19 minutes since we got over the technical problems of casting in 720p. Thank you very much. what does our statistics look like here?
We've had about 200 people regularly here.
Cool.
Sure.
YouTube is telling me that our health is good, 504 hours view time, and 246 concurrent viewers. So we'll call that a stream. I don't think there's too much more to go over. Take a look at chat.
That kind of blows my mind that people have watched our stream for a whole month in the past 2 hours.
What is my hourly rate? Can we pay for more Leonard time?
Can I veto that?
I can pledge to come back and do more live streams. It's just late here. It's now 12:30 here, midnight 30 here. So we're going to be getting ready for bed. And I'll see you guys tomorrow. We'll try and release some videos. I want to make, we have a bunch of videos to make. There's just so many. So, anyway. I love you guys. I am your favorite cone-wearing copyright attorney. Thank you for joining me. Thank you, my staff, for having this impromptu live stream. Thank you, Kaley, for putting up with me for 2.5 hours sitting here talking about this. And I will see you guys. And fetching me drinks and cats. Entertaining the stream with cats. And I will see you guys later. Have a great... Tomorrow, Thursday? Have a great Thursday, Friday... What?
It's Wednesday today.
Today's Wednesday, so tomorrow's Thursday. Okay, cool. So have a great Thursday, Friday, Saturday, Sunday, and I'll see you on the Sunday show. And I'll see you in the next video. And those who don't see me, I hope you have a Happy New Year.